சார் லைவ் சொல்லிட்டீங்களா?
எஸ். ஆடியோ வருது. ஹலோ ஹலோ. ஓகே.
Very good morning to everyone. I am Dr. Rukmani Devi, Professor, Department of ECE, IQAC Coordinator, R.M.D. Engineering College. Hearty welcome to our honorable guest, Mr. S. Thangapandian sir, most respected Principal Dr. N. Envichalyan, R.M.D. Engineering College, beloved Dean Dr. K. Shivaram sir, and my supervisor Dr. P. Rangarajan, and participants, faculty members, industry experts, research scholars, those who are all attending this webinar titled on Patent Act Drafting, Filing System and Challenges in India. Now I invite our principal to brief about our college. Please, sir.
Very good morning to all of you. Hearty welcome to our chief guest, Mr. S. Thangapandian, Deputy Controller of Patents and Design from Chennai. Indeed, we are very much happy that he is with us and he is going to share his knowledge about a Patent Act, drafting, filing system and the challenges that are being faced in India. And particularly during this post-COVID-19 period, what are all the measures that we are going to take, and innovation is going to be the key. So in this scenario, this kind of webinar becomes very imminent. I hope that all of you are safe and be inside your home, and we pray God that our country and throughout the world people should come out happily from their home, and normalcy should come very soon. With the prayers, I am starting my presentation about our college. This will take about 5 to 10 minutes. Let me brief about our group of institutions. Our promoter of our group of institutions, R.M.D. Group, is Honorable through R.S. Muniratnam, founder and chairman, is the dynamic personality, a great visionary and a philanthropist, a former member of the Tamil Nadu Legislative Assembly, and he has been elected 3 times continuously as MLA in succession. He was instrumental in setting up industrial estate, SIPCOT, and Institute of Road and Transport at Gumdipundi. He is currently the president of Consortium of Self-Financing Professional Arts and Science Colleges in Tamil Nadu and the chief patron of All India Federation of Self-Financing Technical Institutions. He received his Vidyaratna Award for outstanding achievements in the field of education for the rural community. And apart from our chairman, this is our management team. Tirumadi Manjula Muniratnam, chairperson. Thiru Jyoti Naidu is our director. Thiru R.M. Kishore is our vice chairman. Thiru Yalamanji Pradeep is our secretary. Dr. Durga Devi Pradeep is our vice chairperson. Tirumadi Soumya Kishore is our trustee. And our R.M.K. group runs 8 institutions: R.M.K. Engineering College, R.M.D. Engineering College, and R.M.K. College of Engineering and Technology. Apart from that, our group has one polytechnic, Sri Durga Devi Polytechnic College, and in addition to this, we have 4 schools. And about our R.M.D. Engineering College, we are well known for our discipline, academics, placement, and hygienic food. R.M.D. Engineering College was established in the year 2001 by Sri Swaminathan Naidu Educational Trust The vision of our institution is to be a premier institution offering quality technical education and research with application expertise in engineering and technology. And related to our 20 years of excellence, it was started in the year 2001. We are marching towards 28th year, and it is approved by ICTE New Delhi, affiliated to Anna University Chennai. All our UG programs are accredited by National Board of Accreditation New Delhi, and it is valid up to June 2023, accredited by NAC, and it is valid up to 2021, and application for autonomous status from this academic year 2002-2021 coming academic year, we have applied to UGC and Anna University. It is under process. We hope that definitely we will become autonomous from this academic year onwards after the UGC visit. And we are also accredited by Tata Consultancy Services. And currently we are running 5 UG programs, 1 PG program, and 3 centers are PhD recognized research centers. And we have BE program in CSE Electronics and Communication Engineering, EEE Electronics and Instrumentation Engineering, and BTech in Information Technology. And from this academic year onwards, we are introducing one more BTech program, Computer Science and Business Systems, in collaboration with Tata Consultancy Services. And we have one PG program, ME in Computer Science and Engineering, Computer Science and Engineering, Mathematics and Physics. These 3 departments are recognized research centers for offering PhD program. And R.M.D. Engineering College always stands at the forefront of engineering education. We are always in the one among the top 10 engineering colleges as far as academic performance is concerned. When the Anna University releases results after that, based on the academic performance, it releases the result. We are one among the top 10, and 93.44% of graduates in 2015-19 batch, 94.82% overall result in 2019 batch, and 19 university ranks in this batch we have produced, out of which 2 are gold medals. And we have signed 24 MOUs with foreign institutions, industries, and academic alliance partners. And we are well known for our recruitment. Placement track record is excellent as far as our RMK group is concerned. There are about 200 plus regular recruiters are visiting every year. Consistently, we are producing above 85% of annual placement conversion. Our day 1 campus placement in the 2020 batch, current final year batch, is total number of students placed is 212. From CTS 102, TCS 36, Wipro 52, and Infosys 22. Our campus placement as on today is 85.7% for this current final year batch. And related to our achievements and recognitions, we have got Bharatiya Vidya Bhavan National Award for Best Overall Performance in the year 2010 by IST New Delhi. We are ranked in NIRF 101 to 150 rank band in 2017 and 151 to 200 rank band in 2018. We have also received Swachhta ranking during the year 2017. Our position is 5th position across the country by MHRD Government of India. And we have also received Best Institutional Food Safety Award by Government of Tamil Nadu. Related to our achievements and recognitions, since inception, we have produced 570 university ranks, 10 gold medals, 7,621 graduates. We are running MHRD's Institution Innovation Cell, and it is 3-star rated. 10 centers of excellence laboratories we have created in collaboration with various top multinational companies. And we are the AICTE CAE survey of best industry linked technical institutes. All our departments are recognized and listed under platinum category, and this is happening consecutively for 4 years. And similarly, MHRD's Smart India Hackathon program, our teams are participating, and we have won 3 first prizes, 2 prizes in 2018, one in software and one in hardware, and one prize, first prize in hardware edition in 2019. And we are having a recognized business incubator, and it is recognized by Ministry of Small and Medium Scale Industries, MSME, with a funding of 150 lakhs. And these are the centers of excellence we have established inside our college. This is one of the main reason our placement track record is very excellent, and business unit hiring. It means that number of students getting more than 5 lakh salary is very high, and we have artificial intelligence COE with collaboration with the CTS Cognizant, big data analytics COE with Virtusa, and building management systems COE with Johnson Controls, factory automation COE in collaboration with Mitsubishi Electric, telecom COE with Wipro, and front-end engineering COE with Virtusa, embedded system COE with Wipro, and automotive electronics COE with KPIT, cyber security COE with Tata Consultancy Services, and cloud computing COE with Virtusa. And another reason is we have an excellent 360-degree overall training and placement program. And so far, number of companies visited is 139. Because of this COVID scenario, number of companies are not able to come. Still, the companies will come. Our placement percentage will increase. As on date, it is 85.7%. Number of students placed is 319, and the number of students registered is 372. And normally we are imparting 600 hours of training with spanning of 4 years, probably up to 7 years, 7th semester. We are conducting our placement training program. It covers various aspects like English, logical ability, quantitative, and personality development and technical skills. This covers the entire skills required for a press engineer, so that the industry he becomes industry ready engineer, and only because of this we are able to produce consistent placement track record. And related to our research activities, we have got a funding of 2.92 crores, and we have established labs also. 25 ongoing consultancy projects we have on hand, and 630 research papers published by faculty in reputed journals since 2010. 11 patents published by the faculty, 21 recognized Anna University supervisors, 110 research scholars pursuing PhD, 58 doctorates we have out of 149 faculty, which approximately amounts to 40%. Our faculty student ratio is 1:15. And related to infrastructure and facilities, we have Center for Higher Education, which teaches GRE, TOEFL, IELTS, etc., and for CAT examination also, and through which nearly about 5 to 10% of our students are going abroad for higher studies or joining in IITs and IIMs. And we have Center for Foreign Languages, which teaches a Japanese language. Because of this, more than 50 offers we have, our students have got, with 24 lakhs yen per annum. We have Center for IPR and Patents, and we have Center for Online Courses. And through Swayam NPTEL, a number of our faculty members and students are handling classes each and every semester. And because of this, throughout India, we are one among the top 100 local chapters, and with AA rating, AA rating. And in addition to this, currently we are having Coursera campus also, through which also our faculty and students are directly they have enrolled courses and they have completed courses. Some of the faculty members and students are continuing their courses, and state-of-the-art computing facilities we have in our campus, and with an internet bandwidth of 410 Mbps, and our campus is entirely Wi-Fi enabled campus. And thank you very much. This is about our college, and thank you, sir, Mr. Tangapandian sir, for your patience, and I have taken more time, and thank you very much. Now it is over to you. Stay home, stay safe. Thank you.
Thank you, sir. Sir, it is my great pleasure to introduce our chief guest, Mr. S. Tangapandian sir, Deputy Controller of Patents and Designs at Indian Patent Office, Chennai Branch, Government of India, Ministry of Commerce and Industry since February 2018. So he joined the service as an examiner of patents and designs in July 2002. Presently, he is handling technical and administration and establishment matters. So he visited many countries, few are here, participated as a member of the Indian team, visited European Patent Academy, EPO, hack program, search and examination working methods for Indian examiners in the year of 2007. Participated as a member in World Intellectual Property Organization Regional Workshop Korea program titled Regional Workshop on Improvement the Effectiveness of Patent Administration Training and Diagnostics.
Our national IPR policy has been published by Government of India in the year 2016. The main objective of the policy, national IPR policy, is creation of awareness in the country. We have been doing this as a part of our duty from our office side. In addition to that, institutions like your R.M.D. Engineering College and so many other institutions are shouldering our responsibility of creating this awareness by organizing such programs. I sincerely thank for the warm introduction and also for the initiation taken by the institution in arranging for this awareness webinar. Shall I proceed to the presentation?
Yes, sir.
Yeah. Now I will share the screen.
Okay, sir.
Yeah. Let me welcome all the participants for this presentation. The main intention of this presentation will be to give a brief introduction to all of you regarding IPR and also to give a detailed information about the patent filing procedures. As I could see from the presentation of Principal Sir that R.M.D. College is already into patents. Okay. I have seen in their presentation they have taken so many initiations regarding establishment of Center of Excellence, R&D departments, by which they got the good industry interactions. I've seen during SAR's presentation that there are so many paper publications taken place from the faculty members of the institution. I really congratulate them for all the efforts taken by them. Let me get into this presentation now. Okay. IPR, as we all know, it is intellectual property rights. It's rights given for sharing your intellectual knowledge to society. What does right? What does the right? It is going to how the right is going to give you any benefit? How are you going to gain from the intellectual property rights? That we will see in the coming slides. We all know when we talk about property, it is our nature. Otherwise, I could say it is our practice that we always think about properties like land, house, or any other property like automobile, vehicles, or jewelry and other things. Jewelry means especially referred to the ladies. So they'll be very keen on accumulating property and jewelry. So only these properties will come to your mind immediately when we talk about the intellectual property. When we talk about the property. Okay. But there is another form of property which we cannot touch and feel, but it is always prevailing within us. It is coming out of our intellectual knowledge. It is coming out of our intellectual mind. That we term it as intellectual property. Okay. So from this flowchart, you can always understand property is categorized into two things. One is tangible and intangible. Tangible, as we have already, I have told you that it is a touch and feel type of thing, like what we know by our tradition, or I could say whatever that has already gone into our mind. We always think about properties listed on the left-hand side under tangible column. So you can see that movable and immovable properties are there. Whereas the intangible type of property, as I told you, which you cannot touch and feel, that type of property comes under intangible property. It is called intellectual property. It's nothing but the creation of your mind with the help of your intellectual knowledge. So that we term it as intellectual property. Okay. Is that enough that we acquire property and we just leave it with that? Is it not necessary for getting actual protection, legal protection for the property? Say, for instance, you acquired a land or a house. Okay, what do you do? What we do actually? We go to, we visit the land, we pay for the land, and we take the land. And the foremost important thing what we do is register the land in our name. So why this registration is very important? Why this legal registration is very important? It is the registered document in your name for a particular land or a house or any other type of property is the proof, is the legal proof which establish your ownership over the property. Similarly, whenever there is an intellectual knowledge, whenever there is an intellectual idea coming out, or whenever you are creating any intellectual property out of your knowledge, doing some innovations, then such type of intellectual property should be properly protected. If not protected, then we will face with legal issues like copying of the property or infringements. Okay. So in order to get away all these things, it is necessary, it is the main requirement to protect it legally. So what are the protections available? What is the right that is going to give you? When you protect it, what is the right you will acquire from the protection? That we will see in the coming slides. So the basic requirement, the creation of innovation is one part. That's very fine. But at the same time, you should also take steps to protect your innovation. Otherwise, whatever efforts you have put in to creating the innovation will go waste. So we'll see in the coming slides. I will try to give an introduction to various forms of IPR, and we'll go into the patents. Okay. So these are the various forms of intellectual property rights. Rather, I would say intellectual properties legally, the protection for which is legally available in our country. Out of this, except trade secrets, okay, we have got legislation for all the other type of intellectual property rights. See, you can see from the list, it starts with patents, trademarks, geographical indications, copyright, industrial designs, trade secrets, integrated circuits registration, plant variety registration. So out of all these things, 8 items, except trade secrets, all other items have got the legal legislation in our country. Okay. So you can very well, once in any form of intellectual property that is created or that is coming out from you can be protected under any one of this provision. Okay. So we need to identify whatever intellectual property what we are creating, that particular intellectual property will come under which category of this type of legislations. That has to be properly identified. So for that, it is very much required. We need to know what each type of intellectual property refers to. Okay. So we'll go into the slides now. First, I will start with the trademarks because the foremost important requirement for starting any business or for running any business or getting a commercial success in a business is the brand name for a product or a company what you are running. So it is always necessary that once you start a business or you become an entrepreneurship and you develop a product, you try to bring the product into the market, it is always necessary there should be a brand name given to the product or the process, whatever you are going to commercialize it. So trademarks is the foremost important. Trademarks refers to brand names in general. We can take it that way. So I have displayed a trademark, a well-known trademark here. It is Honda company. On seeing the name itself, it is very easy for a consumer like us to recognize what this particular name refers to, or what category of uh, uh, company this particular brand, or this particular image refers to. So immediately I am seeing the name Honda and the wings attached to it, I will recognize this to be a trademark of a two-wheeler company, because I know, because Honda is manufacturing two-wheelers, Honda is manufacturing four-wheelers as well. So we always think about the brand name and attach the items which is being manufactured by the particular company. So that is the relationship between the brand name and the consumer. So whenever a consumer sees a brand name, he is immediately correlating the products, correlating the quality of the product, correlating the price of the product, correlating the well-known establishment of the product in the market. This, we know, it's a image. If there is no word displayed, it is only an image displayed. So image, the picture, by seeing the picture itself, we all come to know this belongs to Apple company. Similarly, this is Nike. This is a logo, brand name of a service industry, because this particular name Hilton belongs to a hotel. So even the service industry can have a brand name for their establishment. This you can always identify, well known, and this is also Mercedes-Benz Plastic. So these are the few well-known marks which I have displayed to just give an idea to you how this brand names or just the images are getting connected to the consumers. Okay, the main purpose of having a brand name is, as I told you, on seeing or on thinking of the name of the brand itself, the consumer, it occurs to the consumer about the quality of the product and the image of the product in the market. Yeah, this is another form of trademarks. Okay, earlier we have seen either a single name or a image attached to it. Okay, here you could see image or a picture attached to a caption. Okay, 2 or 3 words put together, they form a caption. So Volkswagen, it is written Volkswagen Das Auto. Okay, it's a caption for the particular brand. Renault, it is passion for life is the caption for. So similarly, if the idea is either a single word or a group of words or an image or a logo combined with words can form a trademark. Okay. Yeah. Now we come to the actual definition of the trademarks as per the Trademarks Act. Okay. Here you can see the basic purpose of the trademarks, as I told you, is to distinguish the goods of one trader from the other in the market. Okay. A trademark can be a word, logo, picture, or a combination of all these things. Fine. To register a trademark, okay, under the definition of the Act, to register a trademark, what is the requirement? How the trademark, how we see any name presented to us in the trademark application form, how we see from trademark registry, how we see whether this is eligible to be a trademark or not. Okay, if the mark is distinctive means it should be distinguished from the other brands. Okay, and not deceptive. Deceptive means the name or the brand name or the image, whatever you are using for your business, it should not mislead the consumer. It should not create confusion in the mind of the consumer. Okay. For example, if I release a brand for any food item, if I say tasty chips, it may not be actually tasty. The consumer has to consume it and they will have to tell that whether it is tasty or not. Or they will have to feel the taste of it. If I just say, put a brand name as tasty chips, then it is actually misleading the consumer. Such brand names, coined words will never be registered. So it should be a distinctive word and it should not be deceptive. And one more requirement is it should not be contrary to any law or morality of the public. Okay. Yeah. Here, this is one very good example for a trademark, how a trademark got connected into the life of people. And normally, when we wanted to take photocopy of the documents, we go to a shop and ask them to give us 5 copies or 10 copies of the Xerox. We tend to say the word Xerox, but Xerox has not did not have any dictionary meaning. It's a brand name of a company. Actual the purpose for which we are going to take copies of these, it's only photocopy. No one, I could say that no one, after going to a shop, they will ask for 10 photocopies. They will only ask for 10 Xerox copies. Okay? So that is the impact a trade name or a brand name will create among the consumers. This is one very good example. You can always, from the picture, you can see the evolution of the trademark since 1906. Okay, the name of the company also changed along with the logo, the design also. It has got evoluted, and to the present brand name and the image of the company, it is appearing in the last box. On the left hand side, you could see that something is written as TM, R within a circle, C within a circle, and SM. See, this is nothing. Once you file an application, to tell the consumers or to tell the competitors that you have filed a trademark application for a brand name, you can mention on your brand name TM, means trademark has been applied. Okay. Once it is registered, you can always mention R within a circle in your brand name along with your brand name. So it means that it will always, the consumers will recognize or the competitors will recognize this particular name has been registered as a trademark. So R within a circle refers to that. SM is a service mark. For any service industry, if you design a brand name, then SM can be mentioned within that. And C, we know it refers to the copyright. Okay. So the trademark, the particular trademark, the Xerox, has become a common word. That is the impact a brand name can create among the consumers. So this is one litigation that has come out when the trademark litigation. You could see the similarity in words. Okay, on the left hand side, it is Nitin Das, a person having an automobile industry in the name of Das Auto. Whereas the other side, you could see the Volkswagen Das Auto is there. Das Auto is actually a German word. Okay, so Das Auto is mentioned there. So there is a litigation came out of this particular case. Das Auto versus Das Auto. So similarly, in market, this type of similarity in words may create confusions. So it is always good. Once you plan to make any brand name for your product, it is always good that you make an assessment of what is available in market and coin a word accordingly for your brand. Okay. So with this, I think I have given a brief introduction to trademarks, which is the basic requirement for starting any business. Then we will proceed to the next topic. This is copyright. Okay. This is another form of intellectual property, right? Okay. So before I could proceed with this, I would say that trademarks right is valid for 10 years, which can be renewed after 10 years as well. What is the right that you are going to get? When I talk about rights, human rights, so certain rights, certain benefits are given for a person holding the intellectual property or who has registered the intellectual property. What is the right going to give you? In case of trademarks, you become the monopoly owner of the brand name and you can prevent others from using the brand name. If supposing others copy your brand name, then definitely you can go for legal suit against the particular person. That's the right you are going to get out of registration of trademarks. Okay. Now we go to copyrights. Copyright, from the picture displayed, it is always easy for us to make an assessment what are all the things that can be covered under copyrights. On the left hand side, first picture you can see a stone sculpture. Okay, so an artistic work can be copyrighted. Okay. Then a musical performance is shown. So musical performance also can be copyrighted. A book is given. So literary work in making a book can be copyrighted. Then cinematography work can be copyrighted. Then Disney picture is shown. So animation pictures can also be copyrighted. In the middle, a CD is shown. Whether do you think the CD can be copyrighted? No. The picture CD refers to the software that is stored inside the CD, the source code of the software, the language in which the software has been written for a particular work, the particular source code or the language in which the software programs have been written that can be copyrighted. Okay. Yeah. So it is actually an exclusive, it is the copyright is an exclusive right granted to the owner for literary, artistic, or scientific work. Literary we have seen, artistic we have seen. What is that scientific work? We'll come to that now. So what are the privileges? As I told you, what are the rights under the when you register? What are the privileges a owner can enjoy? It is to use and authorize others to use. Authorize means you can give a license to others to use. Others means they can obtain license for reproduction from you, public performance, translation, or adaptation. Yeah. Now comes the actual works that can be covered under copyrights. Okay. The first and foremost requirement for any intellectual property to be registered as a right is that particular work, the intellectual work should be a original work. Means it should be a novel work. It should be a new work. It should not be a copy from others' work. Right. That is what is written. You can protect your original work. Okay. Writings, music, sculptures, translations, paintings, lectures, choreographic works, maps, and cinematographic works can be covered under copyrights. More interesting will be the highlighted 3 items for us being technical people. So technical drawings, yes, technical drawings can be copyrighted. Multimedia productions can be copyrighted. Computer programs. See, we all along we have been thinking whether any computer software can be patented or not. No, but the computer programs referred here is the literary work, the source code that is written on a piece of paper. Okay, I'm not talking about the technicality behind the computer program. I'm not talking about the functionality of the program. I'm just talking about the literary work, the language in which the program has been written, the source code. A particular literary work can be copyrighted. Okay, computer program literary work can be copyrighted under this. What about the technicality behind? What about the functionality behind the computer programs? That will come later. This we have already seen. Okay, related rights. Okay, I am a intellectual property owner. I am a copyright owner for a particular performance. Say, for example, a music performance. Okay, let me be a composer for a music composition. Okay, in that case, is that enough that if I prepare a composition and keep silent? No, somebody has to be there for as a singer. Somebody should be there to give for the composition. Somebody has to give the lyrics for that. Somebody has to record it. Somebody has to public performance. So all the others other than the composer who are all coming in bringing the actual work to the public, they are all called, they can enjoy related rights. They are all called neighbors for the owner of the actual copyright. This is especially in terms when it comes to music performance or any cinematographic performance. Here you could see related rights. Okay, neighboring rights. I mentioned to you. An example is given. Say, for example, Isangani Ilayaraja is a composer for a music song. Then he becomes the original owner. What about the other people like performing artist and producer of recordings and broadcasting organization? They all become the neighbor of the particular right and they can enjoy the neighboring rights. Okay. So these are all the rights which we have already discussed. The copyright owner can enjoy. Okay. What is not considered to be copying of a copyright? Supposing I have a copyright on a work. Okay. What are all the acts of others which cannot be treated as a infringement on your copyright? So see, for example, if your work is being used for a research study, then it is not an infringement of your work. When your work is taken for making any criticism, then it is not a copying of your work. Reporting of certain events, definitely not. If any reference is taken from your work for any judicial purpose, no, it is not considered to be an infringement. If it is performed, your work is performed to a non-paying audience, then it is not treated to be an infringement of your work. See, recently we are all aware that some litigation came up with respect to Isangani Ilayaraja musical performance to the public. Okay, so he has legally used his copyright over his intellectual property, copyrighted his rights in his musical compositions and earn money out of it. Okay. So this is the brief idea we have seen about the trademarks and copyrights. Okay. What is the term for a copyright? term for a copyright, the validity of a copyright once registered, it is 60 years from the date of publication. Alternatively, there is one more protection available. It can be 60 years after the lifetime of the creator, whichever is later. Is it actually necessary to register a copyright? Since all along I have been telling you have to register your intellectual property, you have to register your copyright. But now I'm asking a question whether it is actually necessary to register a copyright. Yes, it is actually necessary, but if you are not registered, but and your copyrighted work has become well established among the public, then automatically a moral right is given to you. Okay. Even though you are not registered for a copyright, even though you are not applied under the copyright, a moral right is given to you. But when there is a litigation, when there is an infringement, when somebody has copied and you are going to file a case against him, it becomes necessary for you to establish your moral right. It becomes very difficult in the court of law to establishing a moral right. You have to produce a lot of evidences. Instead, if you have a registered copyright for the particular work, it becomes very easy to come out successfully from the litigation. So, the basic information what I'm trying to pass it on to you is, when it's legally protected, when it is properly registered, it is always helpful to you to enjoy the actual right. Now we pass on to the another intellectual property right, type of intellectual property, which may be interesting for the engineers especially. It is industrial design. Okay, no article exists without a design. Okay, then why design becomes important? Design becomes important. We'll see that. First picture, you can see some car seat is shown. Another picture, it is a chair, it is shown, and a chapel it is shown. See what you can infer from all these pictures. If you ask me, on the first look of it, what I can think about the chair is the comfort of the chair. Okay, and the car seat is the comfort of the car seat. The chair, it is also again a comfort I can feel, but something more is attractive to me on seeing the chair, wooden chair. Okay, what is that more extra? What is attracting me as a consumer? It is the design. It is not necessary the chair has to be in this fashion, but still it is made in this fashion. Why? Means to attract a consumer to buy the product. Okay, so many various designs can be given for the chair. One such design is this. So design always refers to the look of the article, not about the technicality behind the design. Say, for example, somebody can claim in the car seat, somebody can claim by designing such a seat in the car, you will not feel the strain of while you are driving long distance. Okay, that is the ergonomics of the car seat. I'm not talking about the technicality, how it solves the back pain or how it is comfortable to you. I'm not talking about that when it is designed. When it is designed, it is only the look of the article, the look of the apparatus, the look of the device. Okay, so that it is attracting a consumer to buy it. Here, I am furthermore elaborating on this. You can see the definition for design is an ornamental or an aesthetic aspect of an article. When I talk about design registration, it refers only to the ornamental or the aesthetic aspect of an article. Nothing more than that. No technical functions. Okay, it can be a 3-dimensional feature or a 2-dimensional feature also. Okay. Criteria for registration, as I already told you, for any intellectual property, it should be an original work. It should be an original work for a design to be registered. Here you could see 2 pictures mentioned. A citrus fruit juicer. We might have not seen such a type of design, but it is existing. It's a registered design. Okay, so though it has got some benefit, like bringing down the juice to the glass which is placed beneath the juicer, but I'm not talking about the functionality. See the design of it. Will a consumer will be attracted towards such a design when he sees such a design in a showcase of a shop? Okay. Similarly, the bulb, the CFL type of bulb, you could see the bulb can be a normal U-shaped bulb also, but why this type of spiral design has been given? It is only to create an attraction. The function may be the same. It may give the same lux luminous lux intensity, but the attractive feature is the design of the article. So the consumers tend to buy the more attractive thing they compared to the traditional items. Sorry to please excuse me just for 2 minutes. Sorry. So we'll proceed now. Validity for a design registration is 15 years. Actually, it is 10 plus 5 years. 10 years, you can enjoy the monopoly right over the registration, and 5 years, it can be extended. The fourth form of registration is geographical indications registration. Okay. So from the picture itself, we can very easily see what are all covered under geography indications. By virtue of a product, the features of a product, by virtue of its origin, okay, it is registered under geography indications. It is in a way, it is creation of intellectual mind. Okay. Otherwise, it will also take the advantage from the origin of the product. Say on the picture, you can see that Tanjavur doll is there. Okay, it is creation of mind, definitely, but it is manufactured, it is produced in one part of the Tamil Nadu, Tanjore dolls. Nowhere else this type of doll you could see. It is only traditionally manufactured in the particular part of the Tamil Nadu. Okay, the people who are manufacturing it are applying an intellectual input into this. In addition to that, origin from where it is coming out also matters. Second item you could see, Darjeeling tea. Okay, the Darjeeling tea, the flavor of the tea, it is because of its origin. It is not because of maybe because of the cultivation method also, but the flavor of the tea, it is inbuilt into the product because of its origin, because of the land from where it is grown. Okay, the climatic conditions. And the other thing you can always see, ladies will easily identify, it is Kanjivaram sarees. It's a very famous Kanjivaram sarees. Why Kanjivaram sarees are very famous? Because of the silk that is being used and the weaving methodology they are using. Okay, so items which take their advantage or which acquire advantage because of their origin are registered under geography indications. Okay. Only in case of geography indications, this because the Tanjore dolls are it is not a work of single person. Okay, there may be a group of people or association of people working together in manufacturing. So many shops will be there, so many manufacturers will be there, they will be doing it. For a geography indication to be registered, group of people should join together, form an association, apply for the geography indications. The advantage I will tell you, with one example. Recently, the Tamil Nadu State Council for Science and Technology, they have registered a geography indication for Kodaikanal Malai Poondu, Kodaikanal garlic. Okay, it is manufactured only in this, it is cultivated only in this particular region. It has been recently registered under the geography indications registry, and they got a certificate for that also. The price of the garlic was, say for example, 100 rupees before registration. It has gone 4 times more after the registration. So that is the advantage of the registration under geography indications. You may also think over the products or any similar type of agriculture products or man-made products in your own region which can be registered under geography indications. This is till now we have just given a brief information about various forms of intellectual property. Now we'll proceed to our other topic, patents. Okay, patents, it's one form of intellectual property for scientific inventions. From the picture you can easily find out, in the inner circle you could see research is happening. Outcome of the research is you have innovations. What to do with the innovations? You have to go for patents. Okay, then outcome of the patent, one part is commercialization. You have to develop the product and bring it to the market and earn profit out of it. Okay, again it has to be reinvested for research work. so that the technology in our society develops. Outer circle, you could see where these innovations can take place. Innovation can take place in the industry as well as in the society. Society, when I refer, it includes the institutions as well. Okay. Is patents new to us? Because the awareness about the patents, the awareness about the intellectual property among all of us is very, very recently, for the past 3 or 4 years, it is very much under discussion in our country. But it is not a new thing. Patent, it is not a new thing. In fact, intellectual property by itself is not a new thing to our country. It all started in 1856. The legislation, first legislation in our country for patents, for inventions, scientific inventions, is established in 1856. Earlier times, it was not known as Patent Act. It is known as Exclusive Privilege Act. Okay? It is not given in the form of patents. It was given as an exclusive privilege for any innovation. Okay. So, what are the what is that you get from the patent? Patent is a right, monopoly right, given to the owner of the intellectual property, owner of the invention. I would say term define him as an inventor. He is getting a monopoly right from the government. Why government is giving a monopoly right? Is that not a negative right? Monopoly is means you are given the right and other population is restricted from using it. Why government has to do that? Why government has to create a monopoly? The basic reason is particular technology, you have spent your time, money, you come out with an innovation. There should be a reward for that. Okay, so government is rewarding that by giving a monopoly right. Second thing, the idea is once rights is given, you are likely to bring the particular product into the market by which public will be benefited. Third thing is that by bringing the particular product into the market, definitely there is going to be an improvement or development of technology in the society based on the technology already existing. So all these features, all this thinking, all these advantages, government is giving the monopoly right to an innovator. Okay. The basic requirement is the innovator has to fully disclose his innovation to the invention to the government, full disclosure of the technology or know-how to the government. Patent right is again valid for 20 years. Okay, 20 years term starts from the date when you apply for patent. Foremost important about patents, it is a territorial right. See, many times when we go for awareness programs like this, we are likely to get a question that whether if I get a patent, whether I can exercise this patent in other countries outside India, whether this patent is a worldwide patent, whether this patent is a universal patent. No such universal patent is existing. Every country in the world has their own patent act, and based on the patent act, they give patent rights. Okay, and such patent rights is valid within the territory of the respective country. For example, if you take a patent right in India, it is valid within the territory of India only. Okay. So when we talk about innovation, or when we talk about invention, so many people are thinking very complex innovations or inventions. Innovations means they only think that only foreign people can do innovations or inventions. It is not for us. We are only to use the product. We are not to innovate the product. So please get rid of this wrong idea. There are so many innovators, inventors within us, within our country also. They have done a lot of work to bring out the simplicity how an invention can be. I've just displayed these pictures. You could see a safety pin. It works on a basic scientific principle. It is a patented product. Safety pin is a patented product. Okay, this is the best example for a simplest form of an invention. So an invention can be a simple thing also. It need not be a complex thing. An invention or innovation can be a simple thing as well. Okay, please see the picture. It is a safety pin. It is just a strip of, I would say it is a small length of the pin that is bent in the form of to get the spring action into that, and it is used for purpose. I have seen people saying that necessity is the mother of invention. Yes, definitely necessity is the mother of invention. Whenever we come across some necessity, it gives encouragement to us to come out with some innovation. Okay, so such innovation is the safety pin. Complex form of invention. The satellite picture you could see, it is a complex form of invention. It is not termed to be a single invention. There are so many other inventions built into this. So it is a complex form of invention. I have just displayed these pictures to bring out the fact invention need not lie only in the complex items. It can be a simplest form also. Okay. Okay. For any invention or for any innovation to be patented, what is the condition? What are the conditions basically seen or to define an invention? Okay. We in office, patent office, we define a particular innovation as an invention when it satisfies all these three features. One is novelty, inventiveness, and industrial applicability. Okay. Novelty, as I told you, it should be a original work, it should be a new work. Inventiveness, it should have an additional feature, a technical advancement over the already existing product or a process. Your invention should have a technical advancement over already existing process or product. It is the inventiveness. Industrial applicability. Your product or process should be industrially used. That is the requirement. Okay. When your innovation meets all these three requirements, then your invention is defined as a patent eligible invention. Novelty. How do we check novelty? In office, once we receive your document, we study through the document and we'll check for novelty in our database, worldwide database, and find out whether such technology is already existing in any other document, patent document or non-patent document or scientific publications. We'll check through all the documents and find out whether such technology is already existing or not. Okay, or already in public knowledge or not. This is the check we do for novelty. This is done before the date of filing. Supposing you file application today, we don't check after this. We check for technology, for similar technology before the date of your filing. Okay. Okay. This is mainly for the academic people. Okay. I have seen scholars, like PhD scholars, they are making scientific documents, publications. It is necessary for them to obtain the doctorate. They have to present the particular publication in front of a forum where their scientific work is being assessed. Okay, for the academic purpose. So, basic requirement, once you do the invention, what we suggest is don't publish anywhere. You come to office, patent office, file an application first. Then you go do whatever you want. That is the suggestion we give. But when there is a publication that has taken place due purely for the purpose of academic reasons, then there is an exception available. Even though you have published or you have displayed or you have discussed your innovation in front of a team of people for obtaining your doctorate or for obtaining your PG degree, whatever may be the reason, academic reason, in such case, you can come to patent office even after such publication before learned people within 12 months of such happening and file an application here. Your novelty will not be lost. Only thing requirement is you have to prove to us that you have done such publication or you have done such presentation for academic purpose only. Then you are always you will have time. After you are published also, you can come to office within 12 months, you can file an application with this. Okay. This is one exception which will be interesting for the people doing the doctorate work. Inventiveness, as I told you, your particular invention should have a technical feature, additional technical feature, technical advancement over the already existing technology. Industrial applicability we have seen. Okay. There are certain categories of inventions which our government of India restricts from patenting. Why? See, all along we have been thinking that whatever inventions we make, we can get patent. Once it satisfies novelty, inventiveness, and industrial applicability. Fine. But there are certain categories of inventions which are restricted from patenting by Government of India in the interest of the public. Okay, we need to know all these things because you are doing an innovation. Okay, you should not end up with a thing which is not patent eligible, which cannot be patented. So it is necessary for any innovator to know which cannot be patented as well. So in this, if you see, there are a list of items, inventions which are categorized as non-patentable. First, we'll go one by one. One is frivolous or against natural laws. Example I have given within the brackets, like on seeing the name itself, you can very easily think of it, why it is restricted. Perpetual motion machine. Okay. It is against the natural law. It is giving a perpetual motion machine is giving an output without an input. So it can never be established. That particular technology can never be proven. So it is not patentable. Then contrary to any invention which is contrary to public order or morality. Example given, gambling device or adulteration method. Okay, in the interest of the public. Then any invention which is a discovery of mere scientific principle, abstract theory, or living or non-living in the nature. Okay, discovery does not come under the definition of invention. Say for example, Newton has come out with a scientific principle. Okay, I'm not saying that you cannot apply this scientific principle for the development of technology or developing a product. You can very well apply the principle and develop a product, and such product is patentable. But the principle, just the principle is not patentable. Okay, I think you'll be clear what I'm trying to say. The basic principle is not patentable, but any product or any technology, any process built by using the principle is patentable. The other category, any invention which is substance obtained by mere admixture is not patentable. Okay, mere combination of items without any synergistic effect is not patentable. Then comes the method of agriculture or horticulture. Method of agriculture or horticulture definitely cannot be patented. Once you imagine a situation wherein a method of agriculture or horticulture is patented, then we will have to be at the mercy of the particular person for using the particular method of agriculture, doing the cultivation. Okay, so in the interest of the public, it is restricted. Then comes the mere arrangement or rearrangement of known devices, functions independently. Here I would like to give an example. See, sometime back we have seen in the market Chinese product. Though nowadays we should never talk about Chinese products, but still, sometime back we have seen a Chinese product which is an emergency lamp. Okay, emergency lamp in which we have seen a fan attached to it, or a FM radio attached to it, or a torchlight attached to it in a single box. Okay, so all are built into a single cabinet. They work independently. They don't work in relation to each other. Supposing using the device, if you switch on the fan is on, but it does not have a dependency on an FM radio to work. If you switch on the FM radio you can hear the fan will operate separately and FM radio will operate, but they are all inside a single cabinet. This forms an example for mere arrangement or rearrangement of known devices which functions independently. There is no intellectual input into this, so it is not eligible to be a patentable invention. Then comes your process for any medicinal, surgical, curative, prophylactic, diagnostic, therapeutic, or other treatment for humans or animals. Okay. This is again in the interest of the public. Imagine a situation wherein a medicinal or a surgical method is patented. Definitely we will be at the mercy of the particular doctor for using the surgery method. Okay. It will be a monopoly right created. So we cannot create monopoly in such areas. So it is restricted under patentable. But method of treatment is not patentable. At the same time, the equipments, the device used for treating is always patentable. Then comes plants and animals, including seed varieties and species, are not patentable. Excluding microorganisms. Genetically modified microorganisms are patentable. Literary, dramatic, musical, or artistic work are not patentable because this particular work comes under copyrights. Mere scheme, rule, or method of performing mental act or playing a game is not patentable because there is no intellectual input into that, which can be industrially applied. Okay? So it is not patentable. Presentation of information. See, the way I'm delivering my topic, or anybody taking a class, the way they're delivering their particular topic, it's a presentation of information. That methodology can never come under patents. Traditional knowledge. Okay. Traditional knowledge, when you talk about traditional knowledge, very important. The present situation of COVID-19, traditional knowledge, it is the one thing which is which everybody is following nowadays. Okay. The use of turmeric, the use of neem, okay, the use of any other Siddha medicine, all comes under traditional knowledge. When there is a traditional knowledge innovation involving the traditional knowledge, when it is purely based on already known knowledge which is passed on generation to generation. Say, for example, turmeric, it has got some antiseptic property. This particular thing is known for generations. It is passed on from generation to generation. It is a traditional knowledge. When a particular Siddha composition or medicine is made only using the particular property of this turmeric, then it is not patentable. But when there is a composition of so many other items in which one particular component is the turmeric, then the entire composition gives a different effect for curing a disease. That particular composition is definitely patentable. But using one particular knowledge and developing a product, when it comes under the traditional knowledge information, definitely it is not patentable. Section 3, the mere discovery of a new form of a known substance. Okay, here you could see I'm talking about a mere discovery of a new form. Here there is one example our officer faced. Okay, there is an international pharmaceutical company, Novelty company. They have made an anti-cancer drug. Okay, I think the Gilead is the Gilead or some other name, brand name they have given for the anti-cancer drug. Which has been objected and refused by patent office, quoting the reason that this particular drug composition, it's a mere form change. It is a mere new form of an already known substance. So for example, this particular drug composition is already existing. Pharmaceutical chemistry people will clearly understand. Already a patent has been obtained by the particular company for an alpha form of the composition. Now they have filed an application for a beta version of the composition. So our office objected, saying that it's only a form variation. There is no efficacy. Because of the form variation, when the particular company or a person fails to prove the efficacy, then definitely it is not patentable. The example what I told you is for this. Okay, Novartis company failed to prove the efficacy. Okay, the case has gone up to Supreme Court, but it was in favor of the government. So the stand the government has taken, the Supreme Court has made it valid. So any composition, any pharmaceutical composition or any chemical composition which is a mere form change, which is a mere variant without showing any new efficacy, then it is not patentable. Okay. Similarly, mere known use of known process, mission or apparatus. Say, for example, you have a mission for manufacturing a particular product. If the particular mission is used for some other purpose also, the mere purpose will not make it eligible for patenting. Because there is no, when there is a new method or new purpose is found out, there is no intellectual input. It may be by a mere accident, you may find out a different use of a particular mission. So since there is no intellectual input into this particular category of mere use of known process, mission or apparatus does not become eligible for patenting. Then comes the more important thing is a mathematical or business method or a computer program per se or algorithms not patentable. The reason is mathematical method, we think or we define that as a mere literary work. The theorems behind any technology. The technology is different. The technology based on the theorems is definitely patentable, but the mere theorems, mere mathematical models are not patentable. Business method. Any method which involves money transaction or any commercial transaction, say for example your online purchase portals, the methodology they use for delivering the product or collecting the money the particular methodology is not patentable. Then computer program per se. When I say about computer program per se means it is referring only to the computer program as such. Means the source code of the program is not patentable because it is covered under copyright. We have discussed in the previous slide. Okay, so computer program per se or algorithms not patentable because we term these items like computer programs or algorithms to be a literary work, mere literary work, because just by writing a program, it is not going to do any functions. But incorporating this program into a hardware, and that hardware is giving a different result, is for a technical purpose. Okay, definitely it is patentable. But mere computer program or algorithms is not patentable. Application of the program, application of the algorithm for any technology, for any device to bring out a technical output, then definitely it is patentable. Okay, please understand the difference. Many people may get confused, like computer programs are patentable, not patentable means then they will have an impression that altogether the computer programs are not patentable. It's not so. The computer program means only the program as such or the algorithm as such not patentable, but the application of this computer program or algorithm for any technical purpose into an hardware is patentable. There are the other two categories also which are restricted from patentability. One is defense and atomic related, energy related inventions. Any invention which involves atomic materials. Okay, the list of materials is available under Atomic Energy Act. Any invention involving this atomic energy materials definitely not patentable. Again, any invention which are suitable for defense applications are not patentable. But here I would say when we come across an invention which is having a defense application, we don't reject it straight away. Okay, what we do with such applications is we put a secrecy clamping on that. We keep it under confidential records. Okay, then we refer the matter to Defense Ministry for their clearance. Defense Ministry will go through the documents and they will inform us whether it is prejudicial to the defense of India or not. When they confirm that it is not prejudicial to defense of India, then your application will be taken for further processing. But if the Defense Ministry says, yes, it is prejudicial to the defense of India, we stop with that. We don't do any further processing on the application. Okay. Okay. Having seen all these things, we have discussed about the monopoly right the government is giving to the inventor. Then there is two restrictions the government of India for the keeping in view of the concern of the people. One is working of patents in India. When we are discussing about the rights where a person is enjoying under patents, it is mandatory that particular patent, after obtaining a patent, it has to be worked in the territory of India. The main reason is once it is worked or once it is manufactured or marketed within the territory of India, ultimately the public of India is going to be benefited. Okay. So the mandatory requirement after obtaining a patent is it has to be worked within the territory of India. Okay. Then second requirement is compulsory license. Okay. An example is given at the bottom. See, there is a instance where Bayer pharmaceutical company has invented a drug, anti-cancer drug for liver, treatment of liver and kidney. It is called Nexavar. Particular drug, brand name of the drug is Nexavar. Bayer has invented, and they applied for patent, obtained a patent also. But when they brought the particular drug to the market, it was sold at an exorbitant rate. It was sold at 2.8 lakhs, I think, 2.8 lakhs per dosage of the drug. Okay. Imagine middle class or lower middle class people, how is it possible suffering from such a disease, how it is possible for them to obtain the drug and use it? Definitely not possible. So in keeping concern over such issues, Government of India exercised this power of compulsory license and issued a compulsory license to Natco Pharma, which is a generic pharma industry in India. And Natco Pharma obtained compulsory license through Government of India. Okay. And they manufactured the product and they were able to give it in the market at the rate of 9,000 rupees per dosage. So this is how the government makes the checks and balances while issuing a monopoly right. Okay. definitely bare invention is not going to go waste. They have got a license, they have given license as per the terms and conditions directed by the government of India to NATCO Pharma. Their bare also is going to be benefited. At the same time, public also will be benefited. Okay. So we have just seen the definition of invention. We have seen what is patentable, what is not patentable, and what are the concern of government over the public, and what are the checks and balances government will have while giving a monopoly right. Now we will see what to do if you may ask me, say, okay, all these things you have told me, like after as soon as I have come up with an innovation, what I have to do? First thing, do not publish anywhere before filing patent application. This is the first suggestion we give, but we have seen an exception for the purpose of academic reasons. It is always 12 months period is available. Though you publish it, you can come back to patent office and submit a patent application. Your priority will not be lost. Okay, your novelty will not be lost. Okay, so that is an exception for disclosure before a learned society. That is different. But in general, once you come up with an innovation, do not publish your work anywhere before filing a patent application. Second requirement, file a patent application as early as possible. Because why it is mentioned as early as possible is, we work on first to file basis. Whoever comes and files patent application for a particular invention first, he is given the priority. Means his application will be taken on record, application number will be given, date and time of filing will be registered. Anybody coming later with the same type of invention, they will not get, the application will be taken on record. Okay, number will be given, date and time will be given. Okay, but when it comes for processing of patent application, at the time of processing, the person who was filed early, they will get priority over the later one. The later one will not be granted, they will be refused. Okay, so please understand what is the need for coming early to patent office to file a patent application once you come up with an innovation. Check for technical or commercial viability. Okay, that is for commercial reasons. Okay. After complete development, file request for examination. This we'll see in the later slides. Okay. Take a patent. Then after taking a patent, automatically the ultimate aim of patent is to commercialize it. Okay. Though many institutions they file patent and take patent for their own credits, like taking an NIR of ranking or AACT ranking, whatever may be the reasons, they take patents. But they don't take the next step of commercialization. The ultimate goal, the aim, the intention of the government to give a monopoly right is the actual reward comes to the innovator only when the particular patent is fully used. Fully used in the sense only when it is commercialized. Okay. Then field watch. Okay. You have to check for the competitors who are coming up with the same inventions. If somebody is infringing your invention, then you are really likely to file a case against them. Okay. Now we'll come to the filing procedures. Filing a patent application. What are the requirements? Who can file a patent? Okay. Anybody can file a patent. If you are a minor, then you should have a guardian for you to support at the time of filing. Okay. Anybody can file a patent. Any individual can file a patent. Okay. They can file it alone or jointly with other individuals as well. True and first inventor can file a patent. Inventors can file a patent. Here I would like to clarify. See, inventor and there are two categories. One is applicant, second is inventor. Okay. An inventor himself, supposing I have come up with an innovation, then I myself can file as an applicant. Otherwise, in case of institutions, say for example our R.M.D. engineering college, if supposing some faculty or a student is coming out with an innovation, okay, they are making use of the infrastructure of the company institution, and there may be a policy of the institution that whatever intellectual properties that is generated by making use of the infrastructure of the institution are generated while employment or while studying in the institution, that particular intellectual property may be the property of the institution. In that case, the inventor, the faculty or a student can be an inventor. Okay, their names will be mentioned as inventors, and the college institution can file a patent application in the institution name. Okay. So that is the difference between applicant and inventor. The ultimate owner of the patent will be the applicant. Inventor will be the person who has come out with an innovation. There may be a commercial arrangement between the applicant and the inventor, like your college and the student, or college and the faculty. There may be a commercial arrangement that is different. Patent office is not concerned with that. We are concerned. We will only see who are the inventors and in whose name the application has been filed. Who is the applicant? Okay. So I have clarified who is an inventor, who is an applicant, and who is a patent agent. Patent agent is a person who has passed the agent examination conducted by our department and who has registered himself as a patent agent with our office. This person actually acts as a bridge, acts as a facilitator between the applicant, inventor, and the office. So on the applicant behalf, he will prepare all the documents and he will submit to office. He will charge a consultation fee for that, which is not under the control of this department. So it depends on the individual patent agent fixing their own fees. Okay. So agent function is to facilitate the applicant or inventor while filing the patent application and also to facilitate during processing of the application. Here I would like to mention the students or even the faculty members can be maybe interested in knowing this. Like our department conducts a patent agent examination, okay, at least once in 2 years. Okay, this year we have planned in June, but unfortunately because of the current situation, it got postponed indefinitely. But we are very likely to conduct an examination shortly. So once people with a basic science degree, they are eligible to appear for the examination. The requirement is they should know the provisions of the Patent Act. Okay. Once they appear for the examination, they are successful in examination, they can register themselves as an agent with us. It is a profession by itself. Okay. The requirement of patent agents in our country is increasing with increasing awareness, increasing patent filing rate. The requirement of a patent agent is also increasing. So the people can think about this as a freelancing profession or as a mainstream profession as well. This is one extra input I would like to give you. Where to file a patent application? Okay, you all know your institution has already filed a patent application. Around 11 applications have been filed, I think. We have 4 offices established in our country: Chennai, Kolkata, Mumbai, and Delhi. Chennai office takes care of all 5 southern states: okay, Andhra, Telangana, Karnataka, Kerala, Tamil Nadu, and Lakshadweep Islands. Okay. So all these 5 southern states are under the control of Chennai jurisdiction. You can file application here. The application can be filed physically, means you can come to the office, file the application across the counter, or you can send it by India Post, or there is one more option available. You can file e-filing, to the e-filing. If you have a digital signature, you can do filing of all the documents, not only filing the application and paying the fees, but also throughout the process of the patent, whatever documents required by the office or whatever documents you need to file, it can be filed only through online mode. Okay, that facility is 100% available 24/7. Okay. Types of application. There are different types I have listed, but I would mainly focus on ordinary type of application. Okay. I'll just give a brief on what are these types of application. Types of application is ordinary. Ordinary means an application filed by an institution or an individual, okay, without claiming any priority from any other application. Okay, it is called an ordinary application. Convention application. Any application filed under Paris Convention Treaty, it is treated as a convention application. Say, for example, you have many countries of the world registered under or under the agreement of Paris Convention. Okay, these countries, say for example, you have filed a patent application in India. Okay, today, you feel that your product will have a market in US, and you wanted to file a patent application in US. Okay. You have filed today. You have been given a date of filing. You get the priority of that in India. Then when you go to US, I think you will not go the same day. You will go to maybe a month later. You wanted to file an application in US. So you are going to file an application in US. When you go after 1 month, under the convention, US patent office will give you the same date what you have taken from Indian office, because they are all covered, managed, administered under the Paris Convention Treaty. Okay, so that is the benefit of convention application. So Once you file a patent application in India, under convention treaty, you can go to any of the member states of the convention. Within 1 year time, you will get the same priority. Means same date. You will not miss the date, because date is very important for assessing the novelty. So same date you will get. Next comes the PCT application. PCT application, it's covered under Patent Cooperation Treaty. It is again an international arrangement in which many countries are members of it. So it has got its own benefit. Like our convention application, or PCT application is, supposing you file a patent application today in India, then you will have 12 months to file a PCT application. Okay. Under PCT application, the main advantage when compared to convention application is, once you file a PCT application, you can file it through Indian office also. Okay. There is a separate fees applicable that we will discuss later. PCT application, once you file a PCT application, a search report will be generated within 6 to 8 months of time. In the search report, it will be done by any international search authority. India is one search authority. Once the search report is generated, it will give an impression to you whether your invention is actually patent eligible or not, whether novelty is there, or whether inventive step is there or not, whether it is industrially applicable or not. All this information will be there in the search report within 6 months of filing a patent application. So any institution or any organization can take a decision whether they can proceed further with the filing applications in other countries or stop with this based on the report of the PCT. If the report is favorable to them and they have commercial worthiness in other countries, they can very well file applications elsewhere. If the report is not favorable to them, then they can take a decision. We will stop with this, because there is no meaning when there is no novelty at all established in the such report. Then there is no meaning in carrying forward with your patent filing for the same invention in other countries. Okay. So PCT application has got that benefit. Okay. Patent of addition. Patent of addition is, once you file a patent application today, maybe after 6 months, something appears to your mind. Okay, this is the additional innovation which I can add to the already existing patent application. In that case, you can file the particular addition feature as a patent of addition. The main advantage of patent of addition is, the patent of addition, the application filed for patent of addition will go along with your parent application, and it will die along with the parent application once the 20 years period is over. You need not pay any separate renewal fee for this patent of addition. That is the advantage of patent of addition. Okay. Divisional application. See, sometimes when we are into the creation of innovations, when we are doing inventions, scientific inventions, we end up into too many features. Okay. We don't know whether each feature will form a separate invention or not, but it is likely that we club all the features and make one particular system and file a single patent application. When it is taken up for processing, when it comes to the office for processing, when we are looking into it, when we come to an assessment that these items, the features, what is disclosed, what is given in the application can form a topic for separate application, then we will always ask the applicant, we will always ask the person who has filed the application to divide the application, because patent is given for one single inventive concept only. One patent for one single inventive concept. When too many inventive concepts are clubbed together into a single patent application, it is very likely the office will ask you to divide the application as divisional applications. Okay. The advantage is you will not lose the priority. Okay. The divisional application will also have the same date of the parent application. Okay. Then it will be handled separately. So while getting patent, you will get a patent for parent application and you will get a separate patent for your divisional feature also. Then as I've been all along the presentation, I've been insisting mainly about the date. Okay, date is very, very important. First to file the application gets the advantage. Okay, please ensure that once you come up with any idea, it is suggested, it is advised that you please file a patent application first to get the priority. Okay, now we will come to the documents required for filing a patent. Okay. Most of the people who have already filed some patents may be aware what are the documents required, but this is mainly focused for people who are new to the subject and who wanted to have further clarification on the documents required for filing a patent. Documents, the main document, I'm not talking about the application form, that I will tell you in brief later. I'm not talking about the fees to be paid. Okay, the main document which the patent office will scrutinize technically is the specification. Specification is nothing but description of your invention. Okay, so we term it as a specification, but it is nothing but a description of your invention. Okay, there are two categories that are mentioned: provisional specification and complete specification. When it comes to provisional specification, provisional, I can say you can define, or you can for our convenience we can term it as a temporary specification also. Meaning is, as I told you, once you come up with an idea of innovation, just make a framework of the innovation, immediately make a description of that framework and file it as a provisional specification, because date is important. So if you delay in developing the prototype, if you delay in developing the complete test model of the article, and if you delay in finding out the test results, the delay should not take away your priority. So in order to have priority, once you come up with some innovative idea, for which you can develop a frame, you can develop framing of the ideas, you make a description for that and submit it as a provisional specification. Definitely with other forms, application form should be there, other forms should be there, but along with the application form, you can file a provisional specification, attach a provisional specification, submit. We will take it, fees to be paid, and we will take it and we will give an application number for that. Okay, so temporarily I filed a provisional specification. Will that be sufficient? No, that is not sufficient. Office gives you 12 months time for completing your invention. Means maybe based on your field of invention, it is a prototype to be developed, or it is a test to be done for finding out the results of your innovative idea. Whatever reasons, you will get 12 months time to file a complete specification, means final description. Here you can develop upon the idea what you have done at the time of provisional specification. You can develop upon the idea and go further with your invention, develop the entire complete invention, then you file a complete specification. The complete specification is the final description of your invention. Okay, you get 12 months from the date of filing the provisional specification. Advantages, as I already listed to you, advantages of provisional filing is priority you get. Okay, no risk of losing priority. You have 12 months to develop your invention. Okay, yes, which we have already discussed. Then, okay, I have been talking about specification description. What should be the our specification should be, or our description should be? Yes, when you see the topics listed here, immediately, for at least for people doing the paper publications, paper presentations in scientific journals, will be very much aware the work what they do, the basic requirement for a paper publication in a scientific journal, international scientific journal, requires the format of the publication should be in this format. Okay, you can always correlate what the work what you have already done, the document what you have prepared for the paper publication in a scientific journal with the topics listed here. You will find there is no much difference at all. There is no much difference at all. So it is very easy, it is very simple for preparing document for patent filing. So please get rid of the wrong notion that patent documentation is very critical or very complicated. No, it is very, very simple. Okay, you go through these topics listed here. The only topic which may be different from your paper publication will be claims topic, which is highlighted in red. Okay, claims portion is not required when you are filing a provisional application. In detail, I will tell you what is the claims. Otherwise, other topics will be very much clear to you. Content of claims. Okay, content of claims. What a claim? The claim is nothing but point-wise explanation of your invention. Okay, it should be mainly based on the technology what you have disclosed or what you have discussed in the description. Claims in legal language, I would say, it fixes the body of your invention. Okay, Boundary in the sense, when your application goes for any litigation, patent goes for any litigation, court will only read through the claims and find out what is your invention is actually. So while drafting claims, some extra care is required, which you can always gain by going through patent documents or by going through Google and find out any patent document and see the way the claims have been drafted for the particular topic. And you can always gain experience out of the Google search and other patent document search. So once you gain experience, it very becomes simple for you to draft the claims. Main requirement of a claim should be what is given, what the technology that is disclosed in the description should be there in the claims. Nothing extra should be there. First thing. Second thing, claim should be given in simple language and clearly understandable language. Okay. Third thing, you have to cover all the features, all the components that is disclosed in the description within the claim. That's it. Okay. One simple example, I've tried to present it for a claim. You could, if you go through this example, it says a mobile communication terminal comprising a main housing, a folder cover, and a hinge, wherein the folder cover contains a display screen and the main housing contains a keypad. Okay, so in this they are trying to claim. They have already discussed or described this in the specification, the features, the functionality, how it is constructed, the phone is constructed, everything it is there in the description. In addition to that, claims they have drafted. In the claims, they are terming this as not as a mobile phone. They have given the terminology as mobile communication terminal because it is more broader in scope. So they have termed it as mobile communication terminal. If you read through the claims, anybody can easily understand what are the components present in the particular device. The main invention of the device lies only in the folder cover and the keypad, because normally we might have seen when the mobile phone introduced, Nokia company was come out with a device which is single piece with a keypad and screen attached to it. Later date, this type of flip type mobile phones came into existence, and screen is in a different portion and the keypad has been separated. So that is an invention. But they are claiming a mobile phone because only the folder cover will not help. If you get a protection only for the folder cover, you have done invention only in the folder cover. Okay, but if you claim only the folder cover, your protection will be only for the folder cover. With the folder cover, do you think you can be commercially successful? Definitely not. You have to apply this folder cover for a device. Specifically in this case, it's a mobile communication, mobile phone, mobile communication terminal. In that case, it becomes a complete commercial product. So, in a mobile phone, in one portion of the mobile phone, you have done an innovation by introducing a folder cover holding a display screen, and the other part of the cover holds a keypad. That is the innovation. You have used this innovation, applying into the mobile phone, and come out with a new design or new type of mobile phone. This is the claim written for it. Okay? It's the simplest example which I can give you. This is the way. Here I would like to suggest, please go through as many patent documents as possible in your field of invention, so that you will gain an experience how to draft a claim, especially claim. Description, definitely I'm sure, being scholars, you will all very well draft a description. That's not a doubt at all. But when come to claim, you have to take some extra care, gain some experience, and draft the claims. This is the entire patent process. Whatever we discussed, it is displayed in a flowchart form. Okay. Simply, I would like to highlight certain things. When you file a patent application, we will first analyze whether it is complete specification or provisional specification. Okay. If it is a provisional specification, we'll issue application number and keep it on record till we get the complete specification. Because we start the actual processing only when we get the complete specification. Okay. Once complete specification is filed, it will go for publication. Okay. Publication, here you could see there are two types of publication. One is early publication and 18 months publication. Normal course of process. Okay. Once complete specification is filed, it will go for 18 months publication. Means from the date of your filing application, your particular invention, your particular document will be published in our official journal after 18 months. Okay. Then it will go for further processing. Here, many companies, they will always say that why to wait till 18 months? Our product is already ready. We are ready to bring it to the market. Okay, we cannot wait till 18 months for publication to happen. The main purpose of publication, I'll tell you, the main purpose of publication is once it is published in our official journal, the particular owner of the invention will get all the rights as if he has taken a patent. It means rights covered under patents. He can manufacture, he can market it, he can license it, he can sell it. Whatever rights he will enjoy as if he has taken a patent, he will get all the rights once it is published. You need not get a patent. Patent is a later process. Getting a patent certificate is a later process. But talking about the initial process of publication, when it is published, you will get all the rights of a patent owner, except one right. That is filing an infringement suit against somebody who will copy your work. That particular right of filing a case against somebody who is copying your work, you will get it only when you get a patent certificate. Otherwise, you can start enjoying all the rights once it is published. So our advice will always be, we file a patent application, file a complete specification, and get your application published. Then you discuss commercial terms with somebody who may be interested. Then you bring out your invention to the public. Till publication, you maintain it confidentially. That is the advice we give it. Okay. So advantage of publication is this. Two types of publication. Some companies, they may not ready to wait because their product is already ready. They wanted to bring it to the market. They cannot wait till 18 months. Okay. Then there is a facility available for them as early publication. A separate form is there for applying early publication and additional fees to be paid. Once early publication is applied, okay, within 1 month time, say in the first instance itself, you are filing a complete specification or a patent application. You are not going for provisional. You are directly filing a complete. First filing itself complete. Okay. In that case, you can apply for early publication from the date of your applying within a month's time. Normally within a month's time, your application will be published in your journal. The advantage is within a month's time, you can start enjoying most of your rights. Okay. That is the advantage of publication. So you can make use of early publication, or you can go through the normal route of 18 months publication. Okay. The idea is, see, once you file a application, the office will do all the patent process. Okay. And finally, maybe after 2.5 years or 3 years, we'll issue a patent certificate to you. It becomes difficult for an innovator, difficult for an inventor or a patent or a owner of the invention to wait till 3 years to bring his product or to discuss at least commercially with somebody who may be interested to buy the invention till 3 years, because to facilitate that, this in between publication stage has been introduced and it is published. Okay. So no need to wait till you can receive the patent certificate in hand. Once it is published, you can always enjoy the rights, as I told you. Okay. It's one advantage. Then comes the actual patent process. While patent process, examination procedure is there. Examination means it will come, the application, the document will come to the expert. I'm an electrical engineer, so it will come to an examiner of electrical engineering field, a particular application. He will scrutinize the application. He will read through the description, read through the claims, search through the database, find out the novelty, find out the inventiveness of the application, find out whether it is patentable or not, because we have discussed so many items which cannot be patentable. All those assessment he do, and he sends a examination report to the applicant. Once examination report is sent, okay, it is expected the applicant has to reply with all the objections will be there in the report. Based on the objections given, the applicant has to prepare his reply for all the objections and submit it to the office in written. For this, he will have a timeline, 6 months, within 6 months period. Once he receives the first examination report, he has to reply to us within 6 months of period. Any of this 6 months can be extended by another 3 more months. That is during the patent process. That facility is always available. But one thing I would like to emphasize here is the patent office will not arbitrarily refuse your application. Okay? You will always be given a chance. You will always given an option, okay, at any stage to appear before us and explain your invention. Okay. This emphasis I would like to mention. Then after we receive the request for examination is done. Here also, supposing you have not filed the request for examination at all. It's a separate form for request for examination. Application form is separate, request for early publication is separate, and request for examination form is separate. So if you have forgotten or if you have failed to submit application for examination, then what happens? Office will treat your application is withdrawn. Similarly, you file a provisional application, but you forgot the 12 months period. You forgot to submit complete specification. In that condition, what will happen? The office will treat your application to be abandoned. No further action will be taken on that. Okay. So the timelines are very, very important. Once you file an application, it becomes the responsibility of the applicant to keep track of the timelines and meet with the requirements of the office then and there. Not too many timelines, very, very easy to follow that, but at the same time, I wanted to emphasize on the importance of the timelines. Okay. This is the process. We have got pre-grant opposition and post-grant opposition. Means before patent certificate is granted, there is an opposition proceeding is there. Anybody who is aggrieved by your invention or who thinks that this invention is already there in the public domain, then he can come up with the evidence and submit to office saying that you cannot grant patent for this invention because this is already there. We will make an assessment of all the evidences and we come to a conclusion. That is called pre-grant opposition. Okay. Post-grant opposition is there. Supposing you have you got a patent. Okay, you got a patent now, and anybody, maybe your competitor, okay, goes through this patent and finds out that this patent should not have been issued because of this is already in the public domain, or this is for so and so reason this should not have been issued this patent. Patent office has wrongly issued this patent. The evidence is there. Then you can come up with the evidence within 1 year time from the date of your patent, publication of your patent. Within 1 year, you can come and file a patent post-grant opposition. These are the checks and balances in the patent system. Post-grant opposition. Then also, patent office, what we do is we take all the opposition documents, we take the patent documents, then we'll make an assessment comparing both. Then we'll come to a conclusion whether the patent already granted by office is valid, or based on the evidences submitted by the competitor or based on the evidence submitted by in the opposition, whether this patent has to be invalidated. That decision patent office will take. Again, this is not the end. Okay, the decision taken by patent office is not the end. There are other appeal provisions available. Supposing you are a patentee, by some means, this based on the evidence, patent office invalidate your patent. In that case, what you can do is you can always appeal against the decision of the patent office to other forums, higher forums. Intellectual Property Appellate Board is there, High Court is there. So you can always appeal against the decision of the patent office. This is the general patent process we follow. Okay. But if you go through the flow chart, you will come to know the timelines as well. And there are other in-between processes which you can understand easily. Okay. There are certain provisions, as I told you about the early publication. Under examination also, there is a facility available, expedited examination process. Normally, for an examination to happen, it takes 4 months for an examiner to give a report, 3 to 4 months, normal procedure, 3 to 4 months for an examiner to give a report, another 1 month by a controller to assess the report and send it to the applicant. Okay, so 5 months. And 6 months will be there for the applicant to reply back for the report what they have received. So all these timelines all put together, it takes some time, maybe 1.5 years to 2 years time for completing the examination process. Okay, these are all the statutory timelines. It is not the delay that is happening from the office. There may be previously there may be issues with the office that patent office delayed in processing. They have taken 5 years or 6 years period to issue a patent. That is the old story. But now it is not so. We have developed our infrastructure like anything. We have got state-of-the-art online filing facilities, online examination facilities in our office. We purely go only by the online. We don't deal with papers. Okay, so it is all online system available, and the manpower also increased to a greater extent. It can be compared to other international offices. So we have infrastructure-wise, manpower strength-wise, we have developed a lot, and the old stories are gone. Now we take very, very minimum time for issuing a patent. in normal course. Under expedited examination also, the patent from the date of your patent application, it will be taken up for examination under this category, expedited examination, and you are very likely to get a patent within 1 year time. Okay, within 1 year time, that possibility is there. But who will be eligible for making use of this expedited examination process? Who are all the people or who are the institutions they can make use of the expedited examination process? 1 year back, it is only the startups, or it is only the applicants who are selecting. We are talking about PCT application. In that case, whoever selecting India as an international search authority, those applicants, and applicants who are startups category, registered startups, only those two people are able to use this expedited examination because it was on a project phase, pilot project phase. Now it has come to the mainstream, and so many other categories of people are added to the list. Even now, small entity can avail this expedited examination process. Natural person, and in case of joint applicants who are all natural persons. A natural person means individuals, not institutions. Individuals, single individual or many individuals joined together, team members joined together filing a patent application. If among the individuals, or if one single individual is a women, female applicant, then that particular application becomes eligible for this expedited examination. Okay, so my dear participants, please make it a point that you add one women innovator along with your team so that you can make use of this expedited examination, because it goes by that word saying that there is a women behind every successful man. That is made true here. Okay, only you can make use of the facility if you have a women team member into your team when you are applying for patent, this expedited examination. You can go through the list and find out whether your particular institution or organization comes under this category, and you can avail this expedited examination process. This is very simple. Documents required, as I told you, the foremost, the prime document that is more important is Form 2, which is complete or provisional specification that we have discussed in detail. And Form 1 is an application for patent. While filling the application for Form 1, you will need to mention who is the applicant that we have discussed and who are the inventors. And there should be one correspondence address to which the office will communicate. Now all communications are only through email. So you have to mention one active email ID or two active email IDs so that office communications will come to only those email IDs. Okay. So when you go through the form itself, it's all available free of cost in our website, through our website. You can always go through that, and it is very easy, simple to fill up those forms. Form 3, if you have filed any foreign application, patent application for your similar invention, then you need to give the details. Otherwise, a nil statement is more than enough. Form 5, again, you have to list your inventor's name. Say when there is a difference, like inventor and applicant are different. Supposing your institution is the applicant and you are the inventor, then you need to file this Form 5. Okay. Form 18, I was mentioning about the examination procedure, that it has to be requested under Form 18. So for filing a Form 18, normal Form 18 examination, expedited examination Form 18A to be filed. Okay. Talking about the normal route, Form 18, you have to file Form 18 within 48 months from the date of your application. Form 9, it's an early publication request. This is optional. Either you can request for early publication or you can keep quiet till your application gets published after 18 months. So these are the requirements, documents required. And coming to fees, if you are filing as an individual, the 3 categories of fees have been listed in your fee schedule: individuals, startups and MSME, then legal entity, online and physical filing. Fee schedule is given. You can go through the fee schedule from our website. Very, very minimum fees. Okay. Hardly it takes, if you are filing as an individual, it takes at the time of filing, including Form 18 and Form 9, hardly it takes around 8,000 rupees for a patent application. Here, I would like to mention, if you are filing as an individual or if you are joining with other individuals, your team members, to file a patent application, any number of individuals can join together and file as joint applicants, but only one fee need to be paid. Okay. This is a model of the patent certificate, what we were issuing. Okay. Here it will carry patent number, application number, and date of your filing, because date of filing is most important. Then your patentee name, means if your institution is the applicant, they will be termed as patentee after patent is granted. Their name will appear in this. And there is a statement title of the invention is given. The date of grant is given. Okay. Your this particular patent certificate or patent application. This is a PCT which we have discussed. Okay, PCT international application, 6 months you get the advantage of search report. Based on the search report, you can make an assessment whether you wanted to file it other countries or not. Please don't get confused or carried away with the different forms of applications. Now we focus only on ordinary application. Once you are gained expertise in filing an ordinary application, then you can think about a PCT filing an application. Though PCT filing is not a complicated thing, but at least now focus on ordinary application. SIPP scheme. This is one scheme which is administered by our ministry. It's called Startups Intellectual Property Protection Scheme, mainly only for startups. Okay, startups who are registered with our Ministry of Commerce and Industry, they will be getting a certificate as startups with a validity. Those startups are come under the scheme, make use of the scheme. In fact, startups who wanted to file a patent application, okay, they will be helped by patent facilitators. Patent facilitators are no one, they are patent agents listed with us. Okay. Some patent agents are listed as patent facilitators. Among the list, you can approach anyone based on your area or your jurisdiction, approach anyone for helping you in filing a patent application to patent office. And here I would like to mention, Government of India pay the consultation fees to the patent facilitators. The startups need not pay any fee as a consultation fee to the patent facilitators. Only the official fee, application fee, and other fees to be borne by the startups. Otherwise, consultation fee to be given for a patent agent means the patent facilitator need not be given by the startups. The Government of India under the scheme will give the consultation fee in 2 stages. One, at the time of filing, we pay them 10,000 rupees as a consultation fee. At the time of grant, we pay them based on the work they have done. We pay them another 10,000 rupees or 15,000 rupees as a consultation fee to the facilitator. So it is not, the facilitator cannot demand more than this from the startups under this scheme. Okay. This is one main scheme that is running very successfully, and most of the startups are making use of the scheme. And if you have established any startups in an institution or among the people participants, you can make use of the scheme. This is the interface of our website, www.ipindia.nac.in. It's an interface. Through the interface, you can see patent, design, trademarks, GI, all come under single umbrella, all come under the administration of our Controller General. Okay, even copyrights is brought under our administration of our Controller General. Okay, this is the international building photograph. You can see international building in our Delhi campus. You will get all information when you browse through this website. Okay, your comprehensive e-filing facility is given, public search facility is given. Okay, then comes the status, the patent search page. Okay, in the patent search, there is a database maintained, administered by Patent Office. It is called InPass database. It can be accessed through our website. Here you can search through published patents as well as granted patents. You can even check for application status. Your application status is lively available. You can check the application status through this website. Okay. There are so many other fields through which you can put the field and check for the data that is available. Supposing you're coming out with an invention, you wanted to know what are the inventions that is already patented or already published in particular database. You can always make keywords out of the invention or the field to which your invention belongs, and we do a keyword search here with the simple operators. You will get the results. This is European Patent Office interface, search interface. So there are so many databases, free databases in the net available, offered by various patent offices. You wanted to search through Indian database, then this InPass is very much available. If you wanted to search through European patent documents and worldwide patent documents, you can go through this European Patent Office website, you can search. And one more such facility is WIPO, World Intellectual Property Organization, also maintaining a database through which you can search through database of various countries using simple keywords such as. Okay, as I've been all along telling you, after patent, what is to be done? You cannot stop. You please don't stop with getting a patent, though it helps you in acquiring higher positions in your institution, or your career growth is good after obtaining a patent, or your institution credibility is improves after a patent. All that's are fine, but at the same time, you should also focus on commercialization of the patent. Okay. What the importance of the patent is given here. Finally, IP is intellectual property and is also an intellectual profit. One should understand IP is not only the intellectual property, it is also intellectual profit for the innovator. When we talk about scientific inventions, we discuss about the simplicity of the invention, how simple an invention can be. In one line, if you ask me to define invention, I would say it's a solution for a technical problem. Invention is nothing but a solution for a technical problem. Okay, please keep this in. Please keep it recorded. Whenever you are about to do some innovation or invention, you can always think these terms and come out with invention successfully. This is what is expected out of this presentation. So, being technical people or even non-technical people also, whenever we come across any device or any apparatus or any article in our day-to-day life or otherwise in our factory or wherever we are working, we should always have a vision, or our eye should always look for the IPs in the particular article or apparatus. Here, simply a pressure cooker is shown in which various IPs are present. You can clearly understand from the picture. So our vision, our idea should change in such a way that we should not waste the intellectual property we generate. We should make use, we could extract profit from the intellectual property, whatever we are generating. Okay. Thank you so much. And Principal Sir was mentioning that the 600 paper publications done through the institution. I really appreciate and congratulate the owners of the publication. At the same time, only 11 patent applications have been filed. Please fill up the gap. Please fill up the gap. Whatever technical publications that is taking place, please try to convert all those publications into patent applications. It is going to be a order of the future. So, being an institution running so many R&D labs, it is expected that you make use of the facility very well and try to convert your scientific publications into patent applications. That is my sincere and humble request. And I thank you for the opportunity, and I conclude here. Thank you. Thank you.
Sir, thank you for your wonderful presentations. It's very useful for our institutions and those who are all participated in this event. Now I request our Dean Research to propose vote of thanks.
Madam, question answers.
Yeah.
Sir,
the
Sir,
questions are
yes, sir.
the questions are displayed.
Yeah, I have posted the question, ma'am. I have posted the question from participant side.
Okay, sir.
I have asked
Sir,
3 questions.
Sir, please, sir.
Yeah.
If you have a time, kindly answer.
No, I can answer.
Yes, sir.
I just wanted to.
So you can choose your choice, sir, because already you have explained with a lot of information.
No, my point is, if anybody is asking, or I need to go through that, otherwise I will have to.
The participants ask these questions on the go. When you are presenting, participants have asked this question, sir.
Yeah.
You can choose the question to answer.
Yes. I'm not able to see the questions. That's what.
It's in chat box.
I can. Okay, sir. I can.
I'll share this. I'll share this.
Yeah, please.
Sir, how many months or years it take to review and to approve or deny the patent in India?
when discussing, I was mentioning like some 3-4 years back, there is a comment that we take 5 or 6 years to issue a patent. But now the situation for the past 2 years, even for past 3 years, I could say the situation has immensely changed, and we are able to deliver a patent, following all the statutory timelines, legal timelines, not the delay from the side of office, legal timelines. We will be able to deliver a patent within 3 years time. Okay, but this particular 3 years also can be cut short based on the interest of the applicant, because there are certain timelines for the applicant to reply back. If they are able to reply back within a short span of time, then this particular 3 years period also can be shortened. But our aim, the aim of the office, is to reduce this timeline to 18 months period, towards which we are working now. So in shortly, we will be able to deliver a patent certificate within 18 months period. Now, 2 to 3 years period.
Okay, sir. Second question is, can patent be applied with a group of inventors? If so, what is the maximum number in the group?
Yeah, there is no maximum number fixed. Okay, group of inventors as a team member, they can join together. Any number of people can join together and apply for patents. They are being individuals, they will be treated as joint applicants.
Third one, sir. Is it possible to patent our invention as soon as we get the idea of that before hand itself?
Yes, see, that is the idea behind filing a provisional specification. Okay. Once you get an idea, it is not necessary that a prototype should be ready with you. Once you get an idea, you can make a framework of the idea so that it can be presented in the form of a description and file a patent application along with the provisional specification. You need not wait till your invention is completed. Okay. That is what we're discussing. Provisional application, provisional description can be submitted along with application, and the number can be obtained so that you get a priority.
Okay, sir. What about the fee structure to get new patent?
Fee structure, if you are applying as a single individual or a group of individuals together, the fee structure differs between online filing and physical filing. Physical filing, it is 1,750 rupees for application fees alone, Form 1, 1,750 rupees. If you are filing through e-filing module, online module, then the application fees will be for individuals, it will be 1,600 rupees. Other fees like fee for early publication, fee for examination are separate. So all put together, as I told you, the budget will be not more than 8,000 rupees. At the instance of filing, even throughout the process also, it will be 8,000 rupees for obtaining a patent. But there will be certain fees called renewal fees applicable once you get a patent. Once you get a patent for 20 years period, first 2 years is free of cost. From third year onwards, you need to pay minimum renewal fees to keep the patent in force. Renewal fees will differ from year to year. It will differ. It will be very, very minimum. Okay.
Okay, sir. That's it, sir. Thank you, sir.
Thank you.
Over to ma'am.
Yes, sir. Yes, sir. Sir, I request our Dean Research to propose vote of thanks.
It is my proud privilege to propose the vote of thanks for such an excellent webinar, excellent presentation by Mr. Thangapandian, Deputy Controller of Patents, Designs. The presentation was really wonderful, very, very patiently presented, and total details have been given to all of us. And he started right from trademark, then copyrights, then patents, inventions, and types of applications, documents required, fees required, everything. Every part of complete IP rights have been covered. And it was an excellent presentation by you, sir. Thank you so much for your presentation, sir.
Thank you, sir.
I thank our management for permitting us to host such an event, and our principal for his presence and for his excellent presentation on the institution. And I thank all the participants. I thank all the participants who have actively participated in this event. I think when I saw that YouTube I think somewhere around 500 participants were there in this webinar. I'm extremely happy that so many people were interested and then they have interacted with us. So I'm very much thankful to them. Then I thank Dr. Rukmani, who has coordinated and then made arrangements for this presentation, for her excellent coordination. I thank Professor Rangarajan for hosting this entire event. And I thank all our college staff and faculty members who have participated, HODs who have participated in this webinar. Thank you so much, sir, and thank you everyone for participating. Thank you very much.
Thank you.
Okay, thank you, sir.
Thank you, madam. I will
Thank you, sir. Okay, yes.
Thanks.
Okay, madam. Thank you. Excellent, madam.
Sir, thank you, sir.
Okay.
Live இது பண்ணிட்டாங்களா?
Thank you, sir. Thank you, ma'am.